Okay, so um, one of the things I want to talk about now is just what a majority opinion is, a dissenting opinion and just really how cases are presented to the courts. So we already talked about how a party had to submit a writ to even be considered being heard before the Supreme Court. In addition to that, each party will file a brief or a written statement arguing their side of the case. And probably the most important word to know that's right here is the amicus curiae, a friend of the court's brief. So a lot of times interest groups, states, other parties may write amicus curiae briefs, which help to lobby support for one side of the argument or another side. And so it is important to know that term. Once they actually get before the court, each side's only given 30 minutes to make their case, and then they answer questions from the justices. When it comes to writing opinions, these are the key terms that you need to know over here. Understanding the majority opinion, which is the final opinion that the court is handing down, so it becomes the law of the land. So you usually have one justice that will write that, and then there will be concurring opinions that other justices may write to stress other aspects of the case and reasonings for why the decision was made that it was. And then there's the dissenting opinion, and the dissenting opinion does not have legal standing, but it does speak for the people who disagreed with the majority of opinion and why they disagree with the majority opinion. So again, you want to definitely know amicus curiae briefs and the majority opinion, concurring opinion, and minority or dissenting opinion. Okay, so I decided to take us for a little change of scenery to talk a little bit about a deeper concept you have to know, which is judicial restraint versus judicial activism. So we're taking a little walk in my woods, and I'm going to give you a little change of scenery, as well as, so this is the big issue we had this year so far, is that my husband decided that he was going to build a road of sorts in our backyard, but if you can see, he ended up getting himself stuck in the ravine. And so it was like a 2-day process to get him out. It was really pretty crazy. We're now in my backyard. We're continuing our little nature excursion when I discuss judicial activism. And judicial activism is when any level of the federal court system strikes down a law made by Congress or state government, or they reverse a public policy that's been in place for quite a while. So just think about it as justices are really making policy or creating law. And many critics of judicial activism argue that's not the place of the judicial branch, that it's actually hurting the separation of powers and not leaving the right of making laws to Congress. An example of judicial activism, oh, and there's Penny up there by the fence. An example of judicial activism would be the government of Texas had created a law banning abortion. And so if you remember the case Roe versus Wade, that legalized abortion to a certain degree, and that would be an example of judicial activism. Now that's an example of judicial activism in which they're implementing a more liberal idea. But there's also judicial activism that can be from the conservative perspective. So we're back in the woods now, and I'm going to talk a little bit about judicial restraint. So judicial restraint is when the court really just tends to leave cases alone. They basically either choose not to take up cases because they feel like it would be them making public policy, or they actually rule that the courts don't have a role to play here. An example would be, we talked about the redistricting and gerrymandering cases, and most recently the court said that this is really a political issue that needs to be left to the states. It's not the role of the courts to get involved in gerrymandering too much. So that is what judicial restraint is. People who advocate for judicial restraint typically don't believe that the Constitution is a living document. They see it more as been something that's been written, and they want to adhere to it a lot more strictly. So they're more strict constructionists, where people who would be judicial activists are more into that loose constructionism, that the Constitution can be adjusted over time. So actually being back in my woods is kind of distracting when I'm trying to give you guys notes and concepts. But I want to show you this tree that I love. It is full of woodpecker holes because it's a dead tree. So you can see there's all kinds of interesting things going on in there. So the other factor that we need to talk about that helps the courts make decisions is probably the most significant factor to know, and that's stare decisis. Stare decisis. And stare decisis means that the courts are not going to break with precedent. They're going to look at precedents that have been set by the Supreme Court or the lower federal courts, and they're not really going to break with precedent very often. One of the few times that they have, it would be a good example to use, would be Brown versus Board of Education. In that case, they overturned the separate but equal doctrine, dear print, that had been established in Plessy versus Ferguson back after the Civil War. All right, we're back to where we started with the whole Bobcat fiasco. All right, so we're going to talk about some of the checks that exist on the Supreme Court now. So some of the checks that exist that Congress can do is it's really up to Congress to set up the system of the federal courts. So they can kind of define the jurisdiction of the federal courts. They can also decide, how many lower federal courts there will be. If Congress is unhappy with the decision of a court, most of the time the decision is final. So the only way that Congress can really do something is to actually issue a constitutional amendment that changes the Constitution. In that case, then the Supreme Court would have no action that could be taken because they have to follow the words of the Constitution. And finally, the most other important power that exists is in the Senate only, because the Senate has to approve nominees to act as federal judges and Supreme Court justices. So that is a very powerful piece that the Senate has. As far as the rights that the president has, first and foremost, as far as what's actually constitutional, is that the president gets to appoint justices to the Supreme Court. And that can really change, and to the federal courts. So they can really, in recent years, as justices have become more and more, not political, but I guess aligned with certain political viewpoints, the president typically selects a justice nominee that aligns with their either liberal or conservative viewpoints. So it can swing the whole court and the way that the court is going to view topics and issues, whether they're going to do it from more of a loose interpretation of the Constitution, a strict interpretation, or a more judicial activist or judicial restraint interpretation. And we've seen that already with Trump, because he's had the opportunity to appoint 2 new justices to the court. And that has really moved the justice from being more liberal leaning to conservative leaning now. Of course, the other thing that can happen is really it's the president's job and the executive branch's job to enforce the decisions that the court makes. So if the president just decides not to enforce those decisions, then the court's not going to be as powerful. And examples of this would be when Andrew Jackson refused to implement the policy of Worcester versus Georgia, and he still, even though the court said you can't remove the Cherokee from their land, Jackson let it happen anyways. Other examples where the president has chosen to take a stand has been during the civil rights movement, when states were refusing to follow the decision of the Supreme Court in Brown versus Board of Education. So that would be examples of governors ignoring the decision. President Eisenhower and then Kennedy and then Johnson had to come in and enforce those Supreme Court decisions.